A very good morning to you all, and lovely to see you all today. It is -3 in Cumbria where I am today, but nonetheless, a very warm welcome to everyone. Um, just some intros, just while everyone continues to join. So I'm Jenny Beresford-Jones, Senior Legal Advisor, Procurement Specialist in the team here at Mills and Reeve. And it's the 6th of February today, so that means that there are only 17 days to go until the Procurement Act comes into force. That's if you begin your account starting from tomorrow in the proper procurement fashion. And obviously, this is a journey that began with the publication of the Green Paper in December 2020. So it really has been a marathon, or perhaps even an ultra marathon. But we're now on the home straight, which is really exciting. I'm really pleased to be here with Shaylee and with Claire to pass on some of our thoughts as we approach implementation. And many of you will know them, but Shaylee and Claire are the two partners who lead our procurement practice here. Shaylee's on the non-contentious side, acting for suppliers authorities on a whole range of procurement projects. And Claire is on the contentious side, acting for suppliers and authorities on potential procurement challenges and, of course, actual litigation in court. She's the one you hope that you never have to call, which is a shame because it's lovely to work with her. So just a bit of housekeeping. Session is being recorded, and to confirm that the slides and a copy of the recording is going to be circulated. As ever, really welcome your legal questions or observations. Put those in the Q&A box. We don't deal with questions live in the webinar, but we will come back to you with a Q&A document. And again, if you've got any technical issues, Sarah is doing sterling work looking after the technical side, so she will try to help you if you've got any problems. Just a word before we go deeper into it, just an update on a few things that have been happening since we last met in November. Of course, there's PPNs and PPONs. One of the things which we've seen is the release of the procurement specific questionnaire, the PSQ, which was very eagerly awaited. Already we're on version 2 of that because a few days ago they added wording for the PPNs, so prompt payment, which Clara mentioned later, carbon reduction, slavery, steel, and lots of interesting new PPN numbers as well. We've got PPN 15 and 18 on prompt payment has been issued, and query what PPN 16 and 17 are going to be, possibly social value, that remains to be seen. We've also had eagerly awaited some templates for the CFP, the competitive flexible process, and they're already on to version 1.1 of those. I've made some more updates this month to that, so make sure you've got the latest version. And also some more legislation yet to be formally made. Well, it hadn't been when I last checked yesterday, but we've got some draft 2025 regulations, and they actually amend and add detail to the Act and the Procurement Regulations 2024, as well as other legislation such as the provider selection regime regulations, for example. So I think that those ones will come into force on the 24th of Feb. So if you're looking at the Act or any regulations after that date, do make sure that you're looking at the latest revised version. And if you're going on to legislation.gov.uk, you can select that in the display options. And we've also had a bit of sight of the CDP, the Central Digital Platform, which is quite exciting, and the PPON, which is the new name for the Public Procurement Organisation number, which we thought had a lovely ring to it, and some of the people in our team said it reminded of them of in the night garden and things when their children were small. So the PPON is a new acronym. Before I sort of continue, just a reminder of the procurement portal, which has all been refreshed and updated for the Act, although the older material is still on there if you still need it. So do have a look at our notices generator, standstill calculator, and all those useful guides and flowcharts, and all the webinars that we've done previously on the Act as well. Lots of really good stuff on there. So turning to question 1, given that implementation is almost on us, we thought that transition was a pretty key topic. So what is coming into force and when? And when does the Act actually apply? And what we thought would be helpful would be to set out some different basic scenarios and just sort of work out when does the Act apply and when doesn't it. So for your standard above threshold contract, if the tender notice is published on or after 24th of February, then it's the Act that's going to apply to that contract. And again, for the framework, if the tender notice for its procurement was published on or after 24th of February, again, it's the Act that's going to apply to that framework. Those two relatively straightforward. Then looking at a call-off, now whether that's under the framework by way of a direct award mechanism or a mini competition, it's a little bit more complicated, but what you need to do is ask yourself which regime applies to the framework itself. So if the Act applies to the framework, then the Act is going to apply to that call-off. If the PCR 2015 apply to the framework, then they will also apply to that call-off, even if you make it after the 24th of February. So hopefully that's a bit of a helpful way of thinking about it. More tricky is a direct award without competition, and that's because obviously there's no tender notice. So if you look at the guidance on transition, it all depends on when the authority has signalled its intent to make the direct award. If they've signalled their intent to make it before the 24th of February, then it is regulated by the PCR 2015. So what amounts to this signalling, and the guidance says that obviously if you publish something like a VEET notice, that is a clear signal to the market, but it's not the only way, and other means are also possible. So for example, a formal communication of the intent to the supplier and recording that in the audit trail for the direct award. But direct awards are a little bit more complex because they don't have that sort of definite tender notice start date. Variations, again, we take the same approach here as we did earlier on call-off. So what regime applies to the contract that we are looking to vary? If the Act applies to the contract that's being varied, then the Act applies to the variation. If the PCRs apply to it, then the PCRs are going to apply to the variation too. And that's even if the variation is made after 24th of February. And then finally, and actually quite a few people have contacted us to ask us this, what happens if we issue a PIN before 24th of February, but the actual tender notice is published on or after that date? Short answer is the Act applies because the PIN isn't a trigger under the transitional provisions. So you're only into the PCR's regime if the actual tender notice is published before 24th of February. Just a quick word before I hand on to Claire. Some things are not coming into force, and quite hopefully they are some of the most difficult parts of the Act. So it's very welcome that we've got a little bit longer to get our heads around those. So if you look at the transitional provisions as amended to take account of the delay to February, there's a few things missing from the schedule of sections coming into force, particularly sections 13 and 14. That's the duty to have regard to the National Procurement Policy Statement in England and in Wales, and that's because the NPPS is not quite live as yet. And then also significantly, now I won't talk to these too much because I know Claire's going to cover them later, but some of those contract management notice provisions, payments compliant notices, information about payments over 30k, and the really complex one, contract performance notices, none of those are coming into force on 24th of February. And I'll let Claire talk a bit more about that next, actually, because she's going to talk about contract management in the interim period. Thanks, Claire.
Thanks very much, Jenny. Good morning, everyone. So I'm dealing with question 2, which is, as Jenny said, contract management in the interim period. So as many of you will be aware, the reach of the Procurement Act 2023 now extends beyond contract signature into contract management phase of those contracts which fall within the Act's scope. So as Jenny touched upon, several of the key provisions on contract management within the Act will not be implemented on the 24th of February. We don't yet have confirmation of when these provisions will come into force. It's thought that implementation will be linked to the readiness of the central digital platform. And we've also noted some recent references in some of the recent PPNs, which could be indicative of a potential 1st of October 2025 implementation date. But it is very much watch this space for confirmation on that at the moment. Now, as stated there on the slide, the contract performance notice is arguably the most significant of the new notices to be published by contracting authorities as part of the new transparency obligations under the Act. And it's probably the notice under the Act which carries one of, if not the greatest risk of procurement challenge, simply because of the nature of the information which is required to be included in such notices and which will therefore be put out into the public domain on publication. So with that in mind, what delayed implementation does do is afford authorities and suppliers alike to the opportunity to really take some time to understand the notice requirements on contract performance and also the potential impacts that publication of such notices can have when they go out into the market. So it's a real opportunity to best manage processes and potential risks. And so our recommendation would certainly be to use this time wisely to be ready to best navigate the process when it comes into force. So just moving on to the next slide. So drilling down a little bit further into some of the key contract management provisions which are or are not coming into force on the 24th of February. We first looked at payment compliance. Now, Section 68 of the Act, which contains the substantive obligation relating to payments compliance, is coming into force on the 24th of February. So as of that date, there will be an implied term in any public contract under the Act that any sum due to be paid by a contracting authority must be paid within 30 days of the date of the invoice, or if later, whatever date is specified within the contract terms or invoice. However, what isn't coming into force on the 24th of February is Section 69 of the Act, which includes the obligation to issue a payment compliance notice. Now, that's the notice which includes details relating to payments by a contracting authority and sums which are outstanding under the contract. So that's not coming into force. We've also noted there, and it is worth referencing PPNs 15 and 18, which apply to central government, though it is worth noting that the PPNs expressly state that they don't apply to NHS trusts, even though under the Act they are, of course, central government authorities. PPN 15, which does come into force on the 24th of February, requires the authorities to which it applies to set via the PSQ conditions of participation to assess whether a supplier that intends to use a supply chain to deliver its contract has effective payment systems in place to ensure the reliability of that supply chain. There is guidance in the PPN on questions that can be used to assess that. So PPN 18 replaces PPN 15 from the 1st of October 2025, and it does make then some slight changes to those parameters of what's considered prompt payment under the PPN. So when looking at payment compliance, it's definitely worth just having a look at those if you feel you're an authority to which it applies, or it's an authority that's running a procurement that you are participating in. So just moving to the next slide and looking at information about payments themselves, Section 70 is not coming into force on the 24th of February. By way of reminder, Section 70 is the provision which requires a contracting authority to publish specified information about payments of more than £30,000 made under any public contract. So that notice must be published before the end of 30 days, beginning with the last day of the quarter in which the payment is made. As set out there on the slide, at present, we don't know, and it's not entirely clear whether this will be a formal notice to be published on the central digital platform, or perhaps whether it will be the information is published in another way. But again, it's sort of slightly watch this space on that. And finally, in respect of KPIs and contract performance, Section 52 of the Act, which is the provision which obliges contracting authorities to set at least three KPIs where the contract value is over 5 million, that is coming into force on the 24th of February. However, in terms of what information needs to be published in respect to those KPIs, the position is a little bit more nuanced. Regulation 32 of the Procurement Regulations 2024, which is again coming into force on the 24th of February, sets out that where KPIs have been set in accordance with Section 52, a description of each KPI and how often the authority will assess performance against the KPIs must be set out in the contract details notice. Now, as mentioned there on the slide, Section 53, which is the obligation to publish a contract details notice under the Act, is coming into force on the 24th of February. So from that, we know that as of the 24th of February, contracting authorities will be obliged to set those KPIs, at least 3, and to publish details of those KPIs in its contract details notice. However, what isn't coming into force on the 24th of February is Section 71 of the Act. And so there will be no immediate obligation to report on performance against those KPIs and no immediate obligation to report on serious breach or unremedied poor performance. So as mentioned at the outset, there is still time to plan for dealing with these key provisions on contract performance. And as we've noted, they're likely to be controversial. So it's a good opportunity to take the time to plan for those. Thanks, and passing on to Shaylee for question 3.
Thanks, Claire. Good morning, everybody. So I'm going to look at some of the more practical things that we might need to look at to get ready for implementation day. So a good place to start is Section 1 of the Procurement Act, and that looks at the difference between a procurement and a covered procurement. And the concept of a covered procurement is something that's new under the Procurement Act. And as Jenny and Claire have both said, procurement law is going to have something to say not only about the award and entry of contracts, but also about the management of contracts. And that's made clear in the definition of a procurement and a covered procurement. Why is this relevant? It's relevant because the definition of a covered procurement is effectively a public contract that's above threshold and it isn't exempt. The Act is clear on which obligations apply to covered procurement. So things like the Section 12 objectives of delivering value for money, maximising public benefit, acting with and being seen to act with integrity. All of those objectives will apply when you've got a covered procurement. So it's worth looking out for that definition and considering whether that applies to your particular contract. Another part to think about is the rules that apply to below threshold contracts. So we've got the thresholds of £12,000 and these are now inclusive of VAT, and that applies to central government, and that now also includes NHS trusts and foundation trusts. So that's a change from the current position. And then it's £30,000 inclusive of VAT for all other contracting authorities. There are some publication requirements relating to below threshold contracts. So if you are advertising the contract broadly, then you've got to publish a below threshold contract notice. And then in all cases, you've got to publish a below threshold contract details notice as soon as reasonably practicable after entering into the contract. So query what that actually means, but it may well be worth looking at your own internal policy if you're a contracting authority and checking that your thresholds align with those thresholds and you're clear on when those obligations to publish notices will apply. Second point I wanted to mention was just around the transitional provisions that Jenny has just spoken about. So worth looking at which of your contracts will remain subject to the PCR, whether that's the contract itself or if you're calling off from a framework agreement or a DPS that was subject to procurement under the 2015 regs, and also consider which are approaching expiry that you're then going to have to look at reprocuring possibly and thinking about the reprocurement approach, which will likely be under the 23 Act. The next thing I wanted to mention was the pipeline notice. So this is, again, a new notice. The deadline for publishing this for the first of these notices is the end of May of this year. So if you're an authority that spends over £100 million, then contracts which are valued at £2 million or above, where you're going to publish a tender notice or a transparency notice, i.e. a direct award, then you've got to articulate what those are in that notice. The guidance also suggests including call-off contracts within that pipeline notice as well. So worth starting to think about sort of exactly what might be included in the pipeline notice. Look at the central digital platform. Jenny's just about to come on to talk about the central digital platform and what that's going to look like. So I won't say too much about that now. If you're a supplier, it's worth familiarising yourself between the difference between an associated person to you as a supplier and a connected person. So this is important as far as the PSQ goes, where you may well have to disclose information about associated persons or connected persons, and any exclusion grounds, for example, that might apply to them. It's interesting to look at the difference between the two. So the definition of an associated person is where effectively you're relying on that entity to pass the participation stage, but doesn't include guarantors. However, your guarantor, say if it's a parent company, may well be a connected person, and therefore you may well need to disclose information about that connected person in your response to the PSQ. So worth, as a supplier, getting your head around those two definitions and consider where you will need to disclose information about them as part of your bid response. And finally, just a quick word on for authorities on developing procurement documents. So get to know the new PSQ and consider where those PPNs are incorporated in, as Jenny has just mentioned, and also consider developing a standardised CFP process. So using the template that the Cabinet Office has put together, what's going to work for you as an authority so that you can hit the ground running when you are starting your procurements. I will now pass back to Jenny.
Thanks, Shady. Yeah, so just a minute or two on the central digital platform, which has been very sort of eagerly awaited. I think some people on the call on the webinar today might have been involved in the beta testing, but we were on the supplier focused webinar earlier this month, so we did get a bit of a sight of the central digital platform and how it might work. There's several things that we sort of picked up from that on the slide there. I won't talk about all of them. I suppose what I did want to say is that the message that was given on that webinar is that certainly the ambition for the central digital platform is that it really does become a sort of data gathering tool. So, you know, who's spending what, in what sector and in what geographical area. And I think there is an ambition to make these analytics available in the future, together with a database of frameworks and dynamic markets. So I think for both contracting authorities and suppliers, it could end up being sort of a really useful resource. I think some of the, I suppose the key thing that we picked up from the webinar was a bit more detail about how the supplier information service is going to work. So it's going to be a store and share kind of facility. So it's not sort of publicly available to everybody, as I understand it, but the supplier sort of has a space where it creates and uploads its information. And then when it needs to share that with an authority, because it's taking part in a procurement that authority is running, the process seems to be that the supplier creates a share code, which it then passes on to the authority, and that allows the authority's e-sender servers to access that information. And that there are also sort of less techie ways of doing it if the authority requests it, such as sort of downloading a zip file and so on. I think for any suppliers on there, it's quite helpful because it is going to put in information from Companies House, sort of charity type information as well. So the aim is to sort of limit the amount of information that you have to input. We've talked a lot about the fact that the CDP is going to give unique identifiers to organisations, to procurements and to contracts. And certainly for organisations, this is going to be via the PPON, the Public Procurement Organisation number, which is going to be your unique identifier. So it's all just going to go live seamlessly on the current URL, so findatenderservice.gov.uk. That's not changing. And indeed, if you're already registered on there and you've got save searches and settings, we understand that there's no need to update those. So lots of opportunities in the central digital platform, but I think the key thing is how can authorities and suppliers sort of make the most of it and get the most out of it. And I think Shaylee, you were going to pick that one up.
Thanks, Jenny. So we're going to look at it from the perspective of the supplier first. So there is going to be a whole host of information that's going to be available about the market, about competitors. And so it may well be worth considering sort of investing some time or resource into monitoring all of that data to really make the most of that and benefit from that in your own bidding strategy. A key part of that, I think, will be the piece around performance and KPIs that Claire was talking about earlier. And as we see it, we think there's a real opportunity to use the early engagement process to influence that, particularly if there is no real scope in the procurement process to engage with this with the authorities to talk about those KPIs and what they might look like. So using the early market engagement process to influence the choice of KPIs and how those are reflected in the contract documents, I think will be key. Related to that, I think given the flexibilities of the competitive flexible process, making sure that the authorities are thinking about the different opportunities they have and options they have to design a competitive flexible procedure that works for that particular contract, whether that's the inclusion of a demo, for example. That might be something to engage with the suppliers, with the authorities over the early market engagement phase. Also thinking about options and extensions, there is now this obligation to ensure that those are clearly set out in the tender notice to avoid any problems around making modifications later on in the contract. Again, thinking about those and making sure those are clearly thought about at the start and articulated in the tender notice. Thinking again about the KPI regime, given the possible consequences of failing to meet KPIs and the issues around contract performance that Claire was talking about, it might be worth thinking a bit more selectively about the opportunities that you tender for. Is the KPI regime one that you think that you can deliver? And if not, is there an opportunity to engage with the authority to advocate for a different regime? I think that's worth thinking about early, and there's a lot of information from the notices that you can use to inform those discussions. And another sort of point of internal process, if there is a hint of a contract performance notice that's published against you, consider having an internal escalation process that can support you as you sort of navigate that issue with an authority. So if you're an authority, then I think, again, it's useful to use the information that is going to be available to monitor the market, to really inform your own contracting decisions as well, so that you are in step with the market. I think it's fair to say that contracts are contract opportunities are a two-way street. So you are selling your opportunity just as much as you're inviting sort of bids for it. So using all of that information to improve upon the attraction of the contract in the market, I think is useful. Making the most of market engagement. So again, this is a continued thread through the Procurement Act, just as it is under the current rules, really encouraging authorities to use that early market engagement process to better your procurement. So getting feedback on the KPIs, the procurement process and the terms. I think, again, that's that's useful to do at that point. Another point that we've been talking to lots of our authority clients about is really the practicalities of, well, who's publishing which notice and who's going to be responsible, whether that's at the early sort of procurement stage or the contract management stage, and how are those teams going to work together? For example, payment compliance notices, you'll have to work with your finance teams to make sure you've got the relevant data at the right time so you can publish those. And then very finally, I know we're just about running out of time, but if there are opportunities to run voluntary standstill periods throughout the contract management stage, whether that's contract change notice or award of a call-off contract, are you going to have a clear policy on that, or is that going to be assessed on a case-by-case basis? So worth giving early thought to those things. That's all from me.
Thanks, Shaylee. So lots to think about. It is 10:30, so it's time to stop and let you all get on with your day. Do let's have a feedback on the session today. There should be a feedback form coming up at the end of the webinar. And as I said, do look out for the recording and the slides and the Q&A document, which we will circulate as soon as we can. And do have a look at our procurement portal as well. And our next 5 in 25 is, I think, going to be in May 2025. So the Act will have been in force for 3 months or so. We'll be looking at how it has all gone down and talking to any particular tricky issues that seem to be emerging. But for now, that's it. So big thank you from Shaylee, from Claire, from me. Good luck, everybody, for 24th of February, and we will see you on the other side. Thanks very much. Bye.